You've had enough time. But I just want to just bring up something with everything you've said.
Okay.
You were very strict on procedures,
Yes.
right? And you said there has to be a procedure, there has to be a letter submitted. And so far in my journalistic
Findings
and the court proceedings, I have come to realize that a lot of issues are being struck out in court based on technicalities.
Not on this. Not on this.
Well, would you
Not
fault
on this. Not on
procedural
this.
technicality that there was these lawmakers did not actually submit a letter? Probably it could be another side, but there
If we take a decision as a group, if we take a decision, it is not. It is not. It is not.
I don't know where I will start.
I don't want to believe.
You know where I say I don't know. I don't know where I will start because it's a potpourri of questions, and I enjoyed the analysis by my esteemed and distinguished learned colleague. That is the beauty of law, and that is why we find that lawyers, when I even if I don't have matters in court, I just go to court to go and listen to arguments, because I learn one or two. I don't really know where to start, but let me start from the latter part. I think the latter part, if I may understand, is defection. Per se. What is the meaning of defection? Well, I have read so many articles on that. A lot of scholars have come out to say there's political defection and there's legal defection. You understand the point? But the only thing I understand in this particular matter is this. Number one is this. From my own periscoping of the issues here, is that as at the time the Amehule faction, so-called defected, what now happened was this. Who was the speaker as at that time? The speaker as at that time was Amehule. Amehule, who is the speaker, was supposed to receive the letter of defection. Do you understand?
Yes.
But coincidentally, either by accident or by divine arrangement, he was part of the 27 or 20, I don't even know how many they are, 1923, 24, 25. He was part of them. So did they submit the letter to Amehule, who is also defecting? These are the questions the court has to answer. And unfortunately, this matter is subjudiced because it's before the Federal High Court in Abuja. So, but these are pertinent questions. That you transmit the letter to the Speaker of the House, that you are no longer whatever, and the Speaker now will not declare their seat vacant. As at the time the defection took place, it was Amehule that was there. Amehule could not have declared his own seat vacant by virtue of Section 109G. That is the Nigerian political saying we found ourselves anyway. Because people eat their cakes and have it. Let me just use that word. So that is the reason why that did not take place. I don't know how they're going to resolve that. Whether it was proper or they will just do their defection and they will just draw the letter somewhere and say the speaker coming in should come and take the letter. I don't know how that is going to pan out. Two is this. They now said that defection, per se, from what I gathered, because we are learning every day, that for defection to be effective, that you must have to do this first of all. Two, you notify the party you are defecting to from the state to the national, or from national to the state. You address them, you send copies of those letters and the reason why you are defecting, to them and to your own political party. You understand the point now? I don't know if all these things were followed because I am not their lawyer. I have not profiled their cases. Then the next said that once that is done, then your name will now be registered, put on the register of membership of the party you are defecting to. In Nigeria, a lot of things take place. Somebody might defect today, the following day his name is on the register of the party he defected to. So they are saying these are the ingredients that must be present, before an effective defection can be attained. That is the argument. But me, I'm waiting to see how the court is going to decide that. But what concerns me is the former part of your letter. Former part of your question about defection. I think if you can rephrase that question again, that was only about declaration of seats. Whether it is self-executory
or if it's self-executory.
That's the question.
Is that section of the Constitution I asked him if it was self-executory. Okay. I asked with regards to the statement, but the reaction of Ugochinyere to the judgment.
Okay, good. They are no longer members of the yes, good. This matter is still before the court, but I'll just run a little commentary of my own legal argument on this. One is this. For me, Section 109G, I have spoken on this a number of times, not just this place, forum. I've said that Section 109G is not self-executory. It is not self-executory. Now, by operation of law, yes. Now, but let me tell you why. Like the analogy my learned colleague now drew here about dead people, something like that. I want to give an analogy too, because we are all men of parables in Africa. Africa, we talk with parables. What I mean that is not self-executory is this. One, let me give you the analogy. Once your rent of a particular tenancy expires, your tenancy expires today or whatever, you are no longer a tenant of that particular house. You understand? Like what we say, your tenancy, when lawyers write, they say, your tenancy expired by operation of law or by, is it effluxion of time? Effluxion of time. They say, it expired by operation of law or effluxion of time on the 25th November, 2022. Do you understand the point now? Now, by operation of law means that that day, you're a tenant. Is that not so? But because the landlord of the house knows that your tenancy has expired, can he come to your house now and say, your tenancy has expired? He begins to break into your house and take your things out of that particular place? I don't think so, and I don't think that is what happened in law. He cannot go into self-help. He cannot break into that house and throw your things out. Where will he go to? He will run to a court to now inform the court that, look at this man's tenancy has expired, and while that particular matter is going on, the tenant has the right to remain in that particular building, cooking jollof rice and eating amala, ewedu soup. You understand? He can even bring his girlfriend there while the landlord is outside and move around and say, landlord, please open my gate, I want to go inside. Until the court so decide. Do you understand? Until that court decide. When the court decides, say, oh boy, you are arrears of rent, you are going to pay, go and pack his things inside. That is when it becomes effective. I don't know if you understand my analogy. So in this wise also, Section 109 sub G is ambulatory and it's not self-executory. Until and unless, like reaffirmed, by the Court of Appeal yesterday with Section 272 sub 3, that issues that pertain to issues of vacant or vacation of seat or whatever the case may be is before this court. It's this court that has the final say on it. The speaker can say, yes, I have vacated, which is his sole duty. But does that mean that these members cannot go to that house to go and sit down while their matter is pending in court? I don't think that is possible. I don't think that is realistic. Yes, you have said seats have been vacated. But we are in court. And when we are in court, status quo ante has to be maintained. Why that court gives judgment. So do you have the right now to lock me out of the house and push me out and say I cannot come to that assembly? That is what this particular judgment yesterday was trying to say, or is saying. That they can parade themselves as members of the House of Assembly. For peace to reign, they might not go to the assembly building. They can also maintain and live in their living quarters. Because before now, executive governor went there and people thought he was going to demolish that place. But can the governor do that? No, he cannot. Because by virtue of this judgment yesterday, technically speaking, let me use the word, technically speaking, I believe that since that matter of, their tenure or vacant possession of a vacant seat is pending before a court, they have that intrinsically technical right to cohabit, with the others in a firmament called the House of Assembly of Rivers State. But you know what has happened and why this has become so visible and opened a latent gulf where people are beginning to argue unnecessarily over this is because the executive arm of government has come to now join a faction and begin to create a speaker for the governor. Whereas the speaker recognized by the governor is controlling for and putting the other people in hardship. That is not by legal constriction or by legal restraint, but by force majeure and the population, and at the same time the overbearing exuberance of the executive side, a particular side. Finally, on this particular issue, let me tell you why it is not self-executory. Section 109G. It's not self-executory. This. My learned colleague is here. I rushed down to section 4, sub 8 of the 1999 Constitution as amended. That is, it talks about legislative powers. And you go there, look at what it says with permission to read. It says, save as otherwise provided by this Constitution. The exercise of legislative powers, National Assembly, House of Assembly shall be subject to jurisdiction of court of law and of judicial tribunals established by law, and accordingly, the National National Assembly shall not enact any law that has the courts from its jurisdiction. What is he saying? Is it a hero?
Can you just oppose that? 109.
I'm coming. Hold on, sir. Excuse me. I didn't interject you. Please let me flow. Let me flow.
It's a discussion.
This is the problem I have with my LLM friends. Always
discussion. That is,
and we are discussing. You see, we are rubbing minds. I have, let me go back again. I think I remember where I stopped now. Let me say that vigorously, I hold it to say that insofar as Section 109G is concerned, and the action taken by here, whoever the speaker was that said, I declare this seat vacant, was a parliamentary function he performed in his chambers. The courts have the rights to decide on that particular action he took, whether it was right or it was wrong. That is why the Court of Appeal said that jurisdiction falls under Section 272, and it is the courts that have such jurisdiction, and Federal High Court for that particular matter.
No one has doubted that.
Good. And even the local people, this committee say, Abegunde, that all of you quote, people quote, they quote to this Supreme Court, even the African Charter and African Court, ECOWAS Court, etc. It was the Supreme Court that made a pronouncement on Section 109G. It will suit you and also understand that while dependency of this matter continued, Abegunde was still representing, was still in the house. Because the matter was before the court. If you say, please, I'm here on the court to say that until they decide the matter that I am not, that is when I will vacate, I will leave my seat. Technically, he was still contributing to whatever his case may be. So the question I've asked this today is this. Why is the River State all different? And Ugochi is coming to say, and reading it, pungently and very negatively, eschatologically, very purgatorially speaking, he has come to dabble into an issue that is open to judicial debate and legal debate. My submission, therefore, is that, technically speaking, and based on my submission I have given here, their Mehule fashion, as they call them, since the matter is brought a Federal High Court on their vacant, whatever the case may be, should retain that right to be in the House of Assembly, participate in the activities, and follow whatever the proceedings are, pending when the judgment or ruling of court returns. And nobody can asphyxiate or can extinguish or demonize them for whatever reason, as the case may be, unnecessarily. Be you House of Rep members, of Senate members, maybe you governor of the state. Nigeria is governed by the rule of law and not the rule of force. I want to say with due respect, Mr. Governor, allow them to discharge their responsibilities.
I think
if
you
want to be
exception to that because the governor has not prevented these persons from taking.
No.
But when we
I round up because I look at this age. We must have to look at it at a situation like this. They belong to it. You cannot drive them out of that place.
Make statements.
And I don't even know why they have not said. I didn't insult the governor.
I say incite.
Now, when you say inciting, did the governor at any point say
the governor has not? The governor has not prevented them from answered from them
Did the governor at any point say, I gave them a floating? He didn't make that statement. Did he say, I allowed them to, they are existing because
because he said, I only recognize them as they existing because the court of
He has no baptismal right. He has no premature authority to say, he has no right to even recognize. They voted them in the way he was voted in. No. He even belongs to another arm of government. Well, how can you say? Of course, I respect the office of the governor. I cannot say the governor is number one citizen of the state. He must not dabble into legislative affairs. He mustn't do that.
All right.
Please, he should allow these people cohabit with them for rule of law's sake and let the court decide. You know, otherwise, negative or otherwise, these people should be in the house.
All right.
The strength of argument.
No.
Let me
You
respond.
can have your say now.
Strength of argument is not on how you can vibrate, on how large.
You don't need to.
I'm coming.
You know me, that is the way. I have a very, my vocal cord is very high. High decibel. When I'm talking, you know me, it's not today. It's not today. It's not today. I talk without microphone. I don't speak. I speak without a microphone.
Sometimes it's allowed. To make the discussion lively, sometimes it's allowed. I think you are laughing. He's laughing.
I'm not laughing. You know what I'm laughing? You know what what my friend Jabala is, that is the same way we always, I love tangling with him.
Right,
Went to lawyer.
I've said it before now.
Are somehow vibrating. Leave them.
No, are you vibrating?
I'm not now. I don't have that gift of vibration.
No, I'm not vibrating.